Good morning, everyone. Welcome to our seminar and proposed program with respect to the pandemic in your loan portfolio. What's next? I'm Mark Wenzel, and my partner Martha Lehman and I will be making the presentation for you today. I think we are all noticing that things have changed radically in the last couple of months. We all expected problems and issues to be arising in the next couple of years, but I think it's come a lot more quickly than anybody expected. Particularly the COVID situation and the shutting down of our economy has caused significant disruption and much more quickly than we thought. As we say in our intro here, there are only two questions: how bad is it going to be, and is your team going to be prepared? But we have a group here at our firm that's perfectly willing to stand by, ready to help you, and happy to help in any way we can. I'm going to begin by discussing some of the pre-litigation or pre-bankruptcy in particular topics and issues, because that obviously is the place that most of us start with respect to these matters. As we said, the economy is changing quickly. There are lots of bankruptcies that are being filed already. Gold's Gym filed yesterday, and there's a lot of retail bankruptcies that are being discussed and actually filed. So we need to be prepared. And the first step in that process is probably the file evaluation. You can do that either internally or externally. We suggest both. Whatever loan portfolios that you have and problem loans, you may want to have your internal staff take a look through those things. Update your title searches, update your UCC searches, make sure you know what other competing liens and creditors are out there. Do collateral audits. Maybe it's time to do a plant tour or review your inventory and other forms of collateral, make sure it's still there and operating and so forth. In this day and age, with lots of things shut down, it certainly doesn't hurt to make sure that things are insured and protected and so forth. So do those things. And then if you want a separate set of eyes, we are prepared and standing by to help with those things. Sometimes just a separate view, coming at it fresh, gives us an opportunity to see things that you might not catch right out of the gate. Often the next step in the process then would be to make a demand. Often that drafting of the demand letter forces everyone to begin pulling together all the loan documents. The key is obviously it's the current loan documents. What's the current version of the promissory note? What security agreements continue to be controlling the relationship, mortgages, and other sorts of documents. It helps that you pull those documents together and send us copies so that we can begin to review them and make sure we understand what the current form of the debt is. And then sometimes we'll catch problems at this file evaluation or the demand stage. If we figure out that we're not perfected, that we failed to file a financing statement, or something like that, it may be time to slow the process down, file the financing statement, let a 90-day preference period expire, and then take the further step and actually send the demand letter or proceed with something else. Probably that something else often can be a forbearance agreement. We're very positive about them, and we're going to talk in a little bit more detail hereafter about these as well. But conceptually, the big thing with the forbearance agreement is rather than extending and keeping the loan in effect, rather we're saying the loan is in default and you are conceding and acknowledging that in writing in the form of this forbearance agreement. So we leave the loan in a defaulted state, and then the advantage, or one of the significant advantages of a forbearance agreement, is that the forms that we utilize have the debtors admit and acknowledge that they owe the indebtedness. You review briefly the loan documents that evidence the relationship, the notes, the security agreements, guarantees, and so forth, and you have the debtor admit and agree that they are valid and binding agreements and that they have no defenses. Furthermore, we typically include release language in our forbearance agreements that says that they specifically agree that they have no defenses and that they have no claims back against the bank. Often they're resistant to signing those documents, but the argument from the bank's perspective is if you want a concession from the bank in terms of giving them time, then they have to acknowledge that there are no defenses and that we're not going to be fighting about whether the debt is owed or not later on. Another significant advantage of using forbearance agreement is that courts like the idea that you tried to work things out in advance and you gave the debtor an opportunity. So by doing the forbearance agreement, if you have to file suit, courts often take a note of the fact, and we typically attach the forbearance agreement as an exhibit to the complaint to show the court that we've given the debtor an opportunity to try to resolve these things and that it just didn't work out or they couldn't meet the requirements or the conditions for continued forbearance. So again, there are some significant advantages to using a forbearance agreement. Deeds in lieu are another tool that can be utilized. If the debtor's not fighting with you and is saying, look, I know I'm in default and I want to cooperate, it's possible that you can take a deed in lieu from them. Typically, they will want a release, but that's not something that you have to give. However, if they're subordinate liens, there are things that you need to be careful of. We need to make sure that there's no merger. If you accept a deed without putting language in the deed in lieu itself, it's possible that you may result in giving up your position and other subordinate liens may become the first lien because yours goes away. It's definitely possible under Indiana law to provide expressly that that's not to occur, and as long as the documents clearly reflect that, those will be enforceable. Also, you need to be careful about releasing guarantors in that context. Again, we'll talk a little bit more about that later. The next step often is to file suit. We strongly recommend that once you've decided that you've exhausted your other remedies and forbearance periods have expired and so forth, filing the suit is a good thing. You file the lawsuit, the complaint, that starts the clock running. It turns the leverage to your side and forces the debtor to have to deal with the fact that they have to either file an answer or do something. We often also suggest that 20 days after the commencement of the action, you can typically file a summary judgment motion. We typically do that. In fact, we usually use a verified complaint. We will have a bank officer with knowledge of the facts and circumstances swear to the allegations contained in the complaint, and that way it acts as evidence that can be utilized for purposes of summary judgment thereafter. So it's very valuable to do that. It moves the process along. If you file the summary judgment motion 20 days after the filing of the lawsuit, that creates a separate response deadline of approximately 30 days. However, they can ask for further extensions, but if they don't and they don't respond within that 30-day period, you should prevail automatically, or at least there's authority to that effect. So again, it's best to get that leverage going on your side. It forces them to go forward and do something. Another benefit of filing that lawsuit is it's conceivable that you could get them to give you an agreed judgment and then maybe a covenant not to execute, have them admit that they owe you everything, that you're entitled to the judgment, but that you agree that you'll give them 60 or 90 days to do something, get financing, get something different, or then you'll move for a sheriff's sale or something like that. So again, whatever you can do to move the process forward and minimize the legal fees and fighting and expense is certainly a positive. There are times when seeking a receiver will be an advantage. Again, work with your consultants, outside lawyers, and so forth. There are lots of good things that happen with receiver, but there are also some negatives. The cost and expense, if there's not enough equity in the real estate or the property, you may end up having to take the money out of your pocket. Also, receivers typically are often friends of the court, and therefore it's going to be hard to convince a judge to allow you to recover against a receiver on a bond if they make a mistake, or if you want to argue about their fees. There's just a general inclination in Indiana courts to bend over backwards to protect the receiver. So just be aware that there are costs and expenses and issues that relate to that. Briefly, current problems and issues, things we're seeing right now. Obviously we're in this gap period. You finished up a lot of your PPP loans and that sort of stuff. A lot of the bigger problems, once the PPP loans expire or have to start being repaid, we're all expecting in the next 60, 90, 120 days that there will be a significantly larger number of bankruptcies. But what are some of the issues that are arising now? Well, what we've been seeing internally is deferral agreements or extension agreements are, a tool that is being used. Obviously, if you're allowing them 60 or 90 days within which to catch up the payments. A couple of quick issues: you can't balloon those deferred payments under those forbearance sorts of situations. You must amortize them over the remaining term. So make sure not to step into that issue. Also, makers and guarantors, have them sign those extension agreements or change in terms agreements, because if the only form of liability that they have is by signing the original note, let's say there are 3 makers and only 1 signs, an argument can be made that you may have released the other makers by not having them sign. So we strongly suggest that everybody that's on the original debt, if you're going to do a deferral agreement, get everybody to sign. If you have separate written guarantors and they have separate guarantee agreements, they typically waive those defenses, but that's just something that you should be aware of and try not to do anything to release those folks. And then the other big issue that we've seen thus far is leasehold interest and defaults. I've got 2 matters, in fact, right now that involve situations where there are subleases. The ultimate landlord has leased the property to the bank's customer, who in turn then subleases it to a third party. The third parties, often retail places, are, obviously since everything's closed down, they're not getting any income, so they stop making payments under the sublease. The problem is your customer, if it's the tenant and sublease landlord, probably does not have any basis to not make the payments to the ultimate landlord. And we've got a number of situations where landlords are pressing and saying, you got to make the payments to me. It's not my credit risk that your customers, your lease tenants are not paying you. Particularly if you have leasehold mortgages, you've got to be careful that you don't allow your mortgage or the lease itself to be terminated, and therefore you lose any interest in the leasehold interest. So that's probably one of the most immediate and specific problems and issues that we're seeing. Briefly, forbearance agreements, going back a little bit, often the borrowers come to you and ask you to modify. If they do that, then that's a perfect opportunity for you to get them to sign this forbearance agreement. You can call for still modified payments. You can adjust interest rates. You can have a fee. Certainly nothing that prevents you from asking for a fee for them to get an extension. It may or may not apply to the indebtedness. That you can often get the fee and just keep it as an extra kicker for having given them the forbearance. And again, you've got to look at the circumstances and determine, is it worth it? Is there something to be gained by forbearing? Sometimes if it's a lost cause, you're maybe better off just filing the lawsuit, but it is a choice that you got to make. Again, forbearances are analyzed on a case-by-case basis. You have to decide whether it really helps you or not. Consumer context, there are different rules that apply, but we're working with the assumption that most of these are going to be commercial loans that we're talking about today. It should be in writing and signed by both parties. Indiana does have a very strong a statute of frauds for credit agreements that says that unless it's in writing and signed by both parties, it's not enforceable. So protect yourself. Sometimes debtors argue that you promise never to make them pay back the loan. This prevents that from being enforced, and you can often get summary judgment around it, even though they try to create the factual question by claiming that you promised them or something to that effect. Deeds in lieu, again, we've talked a little bit about. It's an alternative foreclosure. Borrower gives the lender the deed. Often they're going to want it to be in full satisfaction of the debt, but you can preserve the deficiency if you ask for that. And again, if there are guarantors, they're going to ask for releases, but it's not required that you give it. The special deed in lieu is often a term that's used when you make sure that you're not giving up your lien. So especially if there are subordinate lien holders behind you, you take the deed in lieu and then you can file a foreclosure anyway. If you're not successful in getting the subordinate lien holders to voluntarily release, you can foreclose them out, and it reduces the number of people with whom you're fighting. Do be careful, though. Deeds in lieu result in you getting into the chain of title, which, if there are environmental issues, can cause liability and exposure for you. So that's it with respect to my portion. Martha's going to take over and talk about bankruptcy basics.
Thank you, Mark. Good morning, everyone. Thank you for joining us. As I said at the beginning, if you're listening to this live, you can use the Q&A function for any questions, and we'll try to answer them. If for some reason we don't get to all your questions, there is contact information for both of us at the back end of the slides, and feel free to contact either one of us offline after the presentation to get some questions answered. We are seeing reports about rising bankruptcy cases, as Mark's already alluded. J. Crew filed Chapter 11 yesterday, which resulted in a panicked text message from my oldest daughter this morning that simply said, "Mom, you must save J. Crew." As Mark's indicated, there are more to come. And for those of you who fall into the lender category, your bankruptcy filings tend to fall into 4 main chapters: Chapter 11, Chapter 7, Chapter 12, and Chapter 13. Most borrowers are going to be filing 7s and 11s. In the consumer context, you'll see Chapter 13s. Chapter 12 is for family farmers, so we're not going to talk about 12 or 13s today. But if you have questions, Mark and I are available to answer them offline. Regardless of the type of case that's been filed, you're going to see some common terminology in every case. You'll frequently hear or see references to a first meeting or a 341 meeting. That's a meeting mandated by Section 341 of the Bankruptcy Code, hence its name. The notice that you will get as a creditor triggers certain deadlines, so it's critical to review the notice when you get it, and we'll talk a little bit more about those notices and what to look for in a couple minutes. The order of discharge is what pretty much every debtor is looking for when they file bankruptcy. The order absolves the debtor from certain debts. If the debtor is confirming a plan under Chapter 11, the discharge typically comes with the order confirming a plan. In a Chapter 12 or a 13 case, that discharge order comes when the debtor completes the plan payments. In a Chapter 7 case, a discharge comes when the deadline for filing discharge objections has passed. And that discharge will occur even if the administration of the case is still ongoing. Your next term you're going to see is discharge objection. Now that comes in one of 2 formats. One is an objection to discharging any portion of the debtor's debts. And let me tell you, that's for really bad behavior on a debtor's part. Or an objection to discharging a particular creditor's claim or claim. So you as an individual creditor could file an objection to the discharge of your claim. Now, discharge litigation can get very complicated and expensive. We're going to be putting additional programs and resources up on our COVID page, and one of them to come in the future is going to discuss this discharge litigation in more detail, so look for that in the future. The next terminology you see up on your screen is secured claim, and claims fall into 4 basic types: secured, undersecured, priority, and unsecured. A secured claim has collateral that's equal to or exceeds the amount of the claim. An undersecured claim is one where the value of the collateral is less than the amount of the claim. And an unsecured claim is one where there's no collateral or the collateral has no value to you as a creditor. For example, Mark was talking about junior lien holders in his presentation. If you happen to be the junior lien holder on real estate worth $300,000 and the senior lien holder's claim is $305,000, you're most likely going to be treated as an unsecured creditor, and the senior claimant is undersecured with an unsecured claim for any amounts over that $300,000 in value. Now, sometimes the courts will need to hold a hearing under Section 506 of the Bankruptcy Code to value collateral for either purposes of plan claims or for plan purposes. When a court does that, the court actually splits an undersecured creditors into 2 claims, a secured piece and an unsecured piece, and that's called bifurcation of the claim. Finally, priority claims are those that are set forth in Section 507 of the Bankruptcy Code, and they tend to include things like domestic support obligations, taxes, consumer deposits, and employee wages and benefits. Near and dear to the hearts of lawyers everywhere, priority claims also include the costs and fees of administering a case, including attorney's fees and other professional fees. And then Mark, if you could slip ahead a couple slides to the first meeting notice. There, perfect. This is a copy of a first meeting notice in the USA Gymnastics case, and I realize it's a little bit small, but I wanted to show you a little bit around it and tell you about the important information that's contained in this notice. In addition, it provides, you'll see, it gives the name of the case, it gives the court where it's filed, it tells you the name, the debtor's address, and you'll see down at about 2/3 of the way down it, the name of the attorney who filed the case. So there's important contact information there. It also, this notice does not, because we don't do this in the Southern District of Indiana, but some districts will include a deadline for filing proofs of claim in these notices. So please pay attention, because the U.S. Supreme Court has said you cannot let that deadline lapse. The notice will set out the deadline for discharge objections. Mark, if you can flip to the next page. You see midway in the middle of the page that date, March 11th, 2019. That was the discharge deadline objection set in that case. And on the first page, what it showed you was where the first meeting was going to take place in the lower right-hand corner there, the date and time. Now, in the past, these first meetings took place in person. The debtor or a representative of the debtor in the case of an entity appeared in person. The witness was put under oath and answers a series of questions about assets, liabilities, and the events that led to the filing. However, in the current environment, most bankruptcy courts are dispensing with in-person meetings. Instead, the notices you're going to start see coming will indicate that the meetings will take place via dedicated phone lines, and parties are going to be able to appear from their offices. There will be paperwork done in advance to prove that the witness is the proper party to appear, but creditors will have the ability to participate by phone and ask questions. When the new filing occurs, Mark, if you could flip to the next slide. You're going to want to talk to your counsel about the value of your collateral, if you have it, because collateral drives so many things, as you will see in this slide in front of you. I'm going to talk about avoidance actions a little bit more, but collateral value drives things like relief from stay, and it drives the issue of whether you can get fees and interest added to your claim, as the slides indicate. A creditor who has a contractual obligation with the debtor and is oversecured can add interest, usually at the non-default rate, and reasonable attorney's fees to the claim. Okay, next slide. All right, in terms of the cases themselves, Chapter 7 relief is available to both individuals and businesses. As it's a liquidation chapter, a trustee is appointed to oversee the case and to make distributions if there are assets available. An individual gets a discharge in Chapter 7, but a business will not. And the reason for that is that a business, if it's liquidating, has no need of a discharge, while a consumer will take the proverbial fresh start and move forward with the remainder of his or her life. The trustee is an interim trustee that is generally selected from a panel of pre-approved trustees for that district. The interim trustee, and I stress the word interim, will go ahead and conduct the first meeting. But if creditors are motivated, they can select a new trustee at the first meeting. I will tell you that that is pretty rare. Mark, can you move to the next slide? I've only seen a trustee election happen twice in 30+ years of doing this. In one instance, the collateral in the industry was so specific that creditors really wanted to elect someone who was familiar with the industry in the belief that it would create better results. In other cases, a few creditors were just trying to generate leverage. They didn't like the trustee much, and they were trying to, send a message early on in the case. I just happened to pick up this morning the most recent version of the ABA Journal, and there is an article on electing trustees and the process and procedure. It's fairly involved, but if you're interested, consult your counsel because it can be a powerful tool for you. Next slide, please. All right, now moving to Chapter 11. In a Chapter 11 case, the debtor generally remains in control of its case and its assets, and is called a debtor in possession or a DIP. Now, things tend to move very quickly in the opening days of a Chapter 11 case. Mark and I both referenced a couple cases that were filed yesterday. My guess is that those DIPs know that they need permission from either the secured lenders or the court in order to use cash collateral. Cash collateral is a term of art, and it's defined by the Bankruptcy Code. It is generally the cash proceeds resulting from the debtor's operations and resulting from the use or sale of a lender's collateral. So, for example, in the case of J. Crew, when J. Crew converts its inventory to sales by cash, that cash or those credit card receipts become cash collateral, and I am sure that J. Crew has a secured inventory lender. If the inventory is of a different type, such as inventory that's shipped out and accounts receivables are created, then the cash generated by the payment of those accounts receivables later on down the road also becomes cash collateral. Now, a DIP needs permission to do a number of things at the inception of the case. Most debtors are going to file what are called first-day motions and seek expedited hearings on those motions. Now, these motions cover things like employment of professionals, use of cash collateral, setting up your administrative procedures for the case, perhaps payment of any employee wages that may have accrued just before the filing but need to be paid within a week or so after the filing, and the use of utility services. The court typically grants interim relief for approximately 10 to 14 days with another hearing to take place before that first interim period expires. So it's essential that you pay attention to the opening days of the case. One important note, last year Congress passed the Small Business Reorganization Act, which created a subchapter of Chapter 11 for small businesses. Our partner Bill Hackney has done a presentation on the SBRA, and it should be on our COVID resource page shortly if it's not already there. Bill's presentation highlights some important differences between small business cases and a large retail case, such as J. Crew. The limitation on debt for a small business case has been enlarged temporarily as a result of the COVID pandemic, and that cap is now approximately $7.5 million. So we are probably going to see a real test of the SBRA and those cases in the coming months. Can you go to the next slide, please? Next slide, please, Mark. Okay. Oh, I'm sorry. Back one. My fault. As I said before, the collateral value drives many things. If the creditor is oversecured, a court's not likely to grant relief from stay, which would let the creditor have access to its collateral. But remember, we've talked about it, the creditor gets to keep the interest and the attorney's fees meter running. Also, a creditor, even an oversecured one, may be able to force the debtor to keep the collateral insured and maintained, pay real estate taxes, and other forms of assessment against the collateral. Now, if a creditor is undersecured, then relief from stay can be more likely. However, if the debtor needs the collateral for a potential reorganization, then the creditor is going to be entitled to what are called adequate protection. And that can be in the form of cash payments. It can be in the form of keeping the collateral maintained. If the value of the collateral is stable, you're not likely to see periodic cash payments. If the value of the collateral is declining, such as trucks in a trucking company case, then you're likely to get some form of adequate protection authorized for an undersecured creditor. The next slide talks about creditors committees. Now, if you're on a member of a financial institution, you're not likely to get asked to serve on the creditors committee, although it can happen from time to time. The materials outline for you various pros and cons. It's important to remember that if you serve on a creditors committee, you have fiduciary duties. So I recommend that you consult counsel before you make a decision about whether to serve if you're asked to do so. Next slide, please. Now, the debtor's goal in filing Chapter 11 is to get a plan confirmed. The plan becomes a new contract between the debtor and its creditors. The debtor will file a proposed plan and a disclosure statement, and the court reviews that proposed disclosure statement to determine if it includes enough information to allow a creditor to make an informed decision about whether to vote yes or no on the plan. Assuming the disclosure statement is approved, the disclosure statement, the plan, and a ballot or ballots will get mailed out to all creditors. I use the word ballots in plural because remember, a creditor that had a bifurcated claim gets 2 votes, one for the secured claim and one for the unsecured claim. Now, each class of claims is reviewed as a group to determine if that class has accepted the plan, and each claim in the class gets a single vote. But the class must accept as a whole, and as the slide indicates, it has to be by 2/3 in the amount of claims and 1/2 in number. So for example, 7 creditors in a particular class vote on the plan. 4 of them have to vote yes. That gives you more than half of the number. But if one of those creditors that votes no has a claim that represents 35% of the amounts due to that class, then that creditor can essentially reject for the entire class. We could hold a day-long seminar on voting and classification, and they're very thorny subjects. The U.S. Supreme Court talks about gerrymandering in political districts, but politicians have nothing on bankruptcy lawyers when it comes to this. So if you feel that your claim isn't being treated appropriately, you want to get your counsel involved at the disclosure statement stage while you still have a chance to potentially impact how your claim is classified and treated. In the interest of time, I'm going to talk about avoidance actions very quickly. The 2 most common are preference claims and voidable transfer or / you may have heard them called fraudulent transfer claims in the past. Now, if a debtor treated a creditor or a group of creditors better than similarly situated creditors in the 90 days before bankruptcy, then those creditors may have received preferences. For example, using J. Crew. If J. Crew had a couple of suppliers that it needed to keep happy in order to keep inventory moving to its warehouses, and those creditors' claims got paid in full, while, say, the delivery services and perhaps their employees or their utilities or their landlords didn't get paid, then those inventory suppliers may have received preferences. But there are defenses under the bankruptcy code, and they're extremely fact-specific. The other typical form of avoidance action is the fraudulent transfer or voidable transfer. And the general idea is that the debtor gave more than it got. A common example is when a subsidiary upstreams a cash dividend to a parent company. That sub got stripped of cash, but probably didn't get anything in return. As the slide indicates, actually fraudulent transfers are transfers that really are designed to remove assets from the reach of creditors, typically for the benefit of insiders. And we're going to be providing a resource in our COVID page, another one of these programs, on preferences and voidable transfers in the near future. So please feel free to review that if you need more information, or contact either of us for any help. And then the next slide, please. And then finally, the slides provide an important reminder about bankruptcy and the ability to sell unique or challenged collateral in a bankruptcy context. Now, this can happen regardless of the chapter of bankruptcy. And it can be a valuable way to dispose of collateral without getting into the chain of title. It may also generate a better return because bankruptcy sales are presumed to create a very specific kind of title, and a title that allows you to get referred to some of those junior lien holders. You have the opportunity to get junior lien holders out of the chain of title, and you as a lender or a creditor never got in the chain of title. As the slides indicate, it's also an opportunity for you, if you're not a lender, but you're otherwise an interested party, whether a competitor or otherwise, an opportunity to acquire assets at a good price or to make a strategic acquisition of an entire line of business. I think that's all we have. If there are any questions, we would be happy to answer them for you.
Again, the page that's up now gives us our contact information as well. Obviously, we've run over a little bit, so to the extent you need to leave, that's fine, but feel free to call either of us with questions and so forth. But we very much appreciate your participating today, and hopefully you found something helpful and useful for you.
Thank you, everyone.
Thanks.